What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast with my dad on week 3 of the Karen Reed trial. We are going to go witness by witness, get his thoughts, who he found more credible, who he didn't. These are a lot of witnesses that he didn't listen to in the first trial. So he's just kind of gone more into the background of the legal arguments, the experts, and things like that. So it's an interesting take on someone who wasn't as familiar with some of the fact testimony in the first trial. So we'll get his takes there. And he's going to share some insights from his career that some questions you guys asked that I didn't have experiences with that he does have some interesting experiences with. So we'll have some story time there as well. Make sure you guys hit the like button. Let's get to it. All right, Dad, here we are, week 3 in the books. And we began the week with the toxicologist before the second part of the toxicologist testimony. And then we ended up getting into some fact witnesses. So what were kind of your thoughts as we went through the week? And then we'll get into witness by witness, breaking it down.
Well, my thoughts were that they've got to start putting things together for the jury because I don't think they've done a good job because they didn't go chronologically. The first trial went chronologically. This one, Brennan, and I'm saying he's wrong. I'm not saying that it's a bad strategy, but the jury still has not caught up. He has not put it together for the jury yet. So they can't put all these pieces together. When I'm watching this, one of the things that I have an advantage over a lot of your listeners and you, I think, is that I didn't watch the whole first trial. And when I'm looking at this, I'm looking at it for the first time, a lot of these witnesses. So I don't know what's coming or what came in the first trial or how this witness fits into a particular piece in the first trial. So when jurors look at this, jurors say to themselves, well, when I finish that witness, what is the impression I have? They may not remember a lot of the specific testimony, but they're going to have an impression after that witness, and they're going to remember the impression they had after the witness finishes. So that's my thoughts when I'm looking through this, is I'm starting to see it that way. I'm looking at myself and I'm realizing that's why I don't see it the same way you do in a lot of these, is because I don't know what's coming or what should come.
Yeah, and I think that's the interesting part about what makes that important is how does the lawyer impeach that witness? If all of us who have watched the first trial are thinking, oh man, that's so different or so much better or so much worse than the first trial, or this is what they said in the first trial, it is up to the lawyer to impeach a witness appropriately so that the jury understands that they've either changed their testimony, they said something good, bad, or different last trial. And that's the important part, and sometimes can be a struggle where the lawyers know it's different. If you've watched the first trial, you know it's different, but it doesn't come across as incredibly different or bad to a juror or somebody like you. So where do you want to start with week 3?
Well, let's go ahead and be chronological. Let's go ahead and go with that toxicologist because it's a very short comment that I have. And the comment is, this jury believes that Karen Reed was drunk. I don't think there's any question about it. They put the toxicologist out there, yeah, but it's the other stuff, the voicemails and those kind of things. So, and the history of how much she had to drink and when she drank and how many bars she went to and all that stuff. So I don't think there's any question she was drunk. And so, and that's another.
I definitely think they believe she was over the legal limit and drove. Like, I don't think there's any real doubt. And for the people wondering, right, what does proof beyond a reasonable doubt look like? Well, you have videos of her drinking over and over again. You have some kind, even if I think we could have destroyed this extrapolation if this was a DUI trial, if you want my honest opinion, with experts about how the blood draw was, when it was, what happened before, what happened after, what they don't know happened after 12:45. Did she drink anything else? But they have somewhat of an extrapolation, and she admits to being tipsy, to probably driving extra careful, to having X amount of drinks. It was probably 4, but the 4 may have been 6. Or that's what proof beyond a reasonable doubt looks like to drinking and driving. And that is in major contrast to proving that she hit John O'Keefe with her car, right? And that's the problem. If you want to know what proof beyond a reasonable doubt looks like, think about how they're proving she drank and drove over the legal limit and compare it with everything else.
And also keep in mind what the charges are. It's another thing that I've caught myself doing, is forgetting about what really the charges are that they're looking at, and to keep those in mind when they're doing the proof. You got second-degree murder, DUI manslaughter, and then leaving the scene causing death. The DUI manslaughter was the one that they did not have a unanimous verdict on in the first trial. And so now you see one of the elements of that is driving drunk. I think that they have proved one of the key elements of the DUI manslaughter. So the driving drunk part's important. And that's why, again, in my opinion, that's the only charge they should have gone to trial on.
Right.
They really should have dropped counts 1 and 3 and just done the DUI manslaughter, because proving second-degree murder, which has some kind of intent, and proving leaving the scene causing death, again, some kind of intent. But the DUI manslaughter, the only real intent is you were driving drunk, and it translates to killing somebody.
All of them have to involve her car hitting John O'Keefe, and she causes John O'Keefe's death while driving drunk, right? So
Right.
that's the element that everybody's still waiting for, that is common throughout all three charges, is she had to cause the death of John O'Keefe by hitting him with her car. And that's the difficult element that they've had trouble proving. But I agree with you when it comes to the driving drunk part. I think they're getting there with the jury. I think the jury is probably saying, okay, that's true.
Right. So, and that's why I think the first witness, even though you're right, you could have torn him up a little bit. The jury, it's a waste of time to really argue she wasn't drunk. I just think it's a waste of time.
Yeah, I agree. And saying everybody else is drunk, while that may be a good public argument to like, all these people were drinking and driving, but only she is the one getting charged with it. It's like, yeah, exactly. It's her trial. She's charged with it. The fact that everybody else was drinking and driving is not really relevant to whether or not she hit John O'Keefe with her car. So, I mean, that's something a lot of people are talking about as well. All right. Next witness was Ryan Nagel.
All right. Now, Nagel, I mean, when I listened to Nagel, I didn't think his testimony was that exciting. And if I was the jury, the one thing I would have remembered, the fact that he didn't see tire tracks. For some reason, that's stuck in my mind. And we know that's going to be in conflict with McCabe, who did see tire tracks. So that's stuck in my mind. The fact he was there to get his sister was inside the house. That's important, who was inside the house. And he left without her. And then another thing that kind of goes through this as you go through it, it doesn't seem like they talked as much as I think they should about the Jeep. But with Nagel, I think the only thing I remember is the fact that he didn't see the tire tracks and he didn't leave with his sister.
Well, I mean, I think the important part of his testimony is he saw Karen Reed inside her car, or a woman in the dome light, and didn't see a passenger, but he could have been in the car. He could have been outside the car. He could have been somewhere else. He didn't see him laying in the snow. He didn't see him walk up to the door. And before you respond to that, I think what's interesting is you're looking for consistencies and inconsistencies between the Commonwealth's own witnesses. And that's a big deal when they're inconsistent, even to something like the tire tracks. And I also think as far as the Jeep, even though the defense didn't dig in on it, he described what he saw and he didn't describe a Jeep, and they can still argue that in closing.
Right. And they were also, I mean, if you want to really talk about somebody could have stood next to the car. Yeah. They were inconsistent in their questioning. Yeah, he could have been right there next to the car. And then the next set of questions a little while later is, you didn't see anybody walk here. You didn't see him go there. You didn't see him go there. So he could have been there, but he could have not been there. Basically,
so what does that prove?
Right.
It's like, so that doesn't prove much, but
it doesn't.
Both sides is going to try to act like that proves everything. Right.
Right.
Then we had Heather Maxon and Sarah.
I'm sorry. I don't think the jury really honed in on that.
I think the jury, if you want my opinion, I think the jury probably thinks it's more important than we do. That they said there was nobody in the front seat of that car. I think the jury is going to take a lot from that. Like if you listen to the interview from the last time, there were certain things the jury was like, oh, well, there's something, because there's just so little testimony and witnesses about what actually happened on the lawn of 34 Fairview. And so whatever they got, I feel like they probably attach on to as much as they can, because we got all this other stuff, right? What happened before, what happened after, call, text message, Waze, CF McCarthy. But it's like, what actually happened in the few minutes that the Lexus was at 34 Fairview, because everybody agrees it was there at some point. So who can actually tell us what happened? And if they're saying that's when John O'Keefe got out of the car, I do think there are some jurors that might find that pretty important.
And jurors like to be detectives. You're right. And you're right. They could have, they're trying to read something into it.
Mm-hmm. Okay. Then we had Heather Maxon, Ryan Nagel's ex-girlfriend, Sarah Levenson, more fact witnesses kind of to those same facts. What did you find important there?
Well, Levinson, the thing again stuck out to me that she didn't see the dog.
That's wild.
And right. And she also said that the dog doesn't like strangers.
No, she
That
didn't say that.
well,
She was asked that, and she
right.
said she doesn't know. She just knows she's never met the dog.
I thought there was testimony that the dog didn't like strangers and that there was an objection.
And so for those people listening, this is
Okay.
why it's so important for the questions that lawyers ask. My dad heard the question asked and thought that that was her testimony, and that's very common. I would do the same thing, right? Like when I remember back facts, sometimes you remember what the question was asked by the lawyer. She did not say that she knew that. She said, I think she said that and again, this may have been a question too, but I think she said that it was not good with other dogs, is what she knew. She didn't know if it was not good with strangers or other people, but she had never met the dog, and she doesn't know really why the reason is. But that was absolutely a question asked to her, that the dog was not good with strangers. So that's a great explanation and illustration about what is the jury going to remember.
You're right. You're right. That is. And for me, for thinking that was testimony.
You're sitting here and you're listening while you're doing other stuff, and I get it. I'm listening on 2 times speed. So some stuff comes in differently, but that's a great illustration, literally, and it happens to me too, right? The jurors are hopefully more locked in because that's all they're doing, but it absolutely happens, and that's why judges make those statements that questions are not evidence. Make sure you're listening to the answer. That's the evidence in the case.
Okay. The other thing that I thought was important was she saw nothing in the lawn. But she heard Julie Nagel say she saw something. Again, so I thought that was also important testimony, that she saw nothing. She
testified to that in this trial? Gosh, I don't remember that at all.
I must have.
That was last trial.
Yeah.
That was last trial that Julie Nagel said she saw the blob. I could have missed that in this trial. So there you go. And that's kind of the point, is we both are watching the same thing, and we both come away with different facts that we think were testified to. I think that's a great illustration, honestly. Like, everybody who is watching this twice, watching recaps, slowing it down, rewinding it, you have a different experience than the jurors have. And I think that's an illustration here that what we're showing. But I do think it's important that she says she walked out of the house at a certain time at night, didn't see the body in the snow. They drove away, didn't see a body in the snow, because last time that was absolutely confirmed with 20 witnesses that left that house. This time they're not calling all those witnesses. So only a couple witnesses are saying, I left after 12:32 and didn't see his body in the snow, which is a pretty wild fact in this case.
And then the other thing, if I was a jury, is I'd sit around and think about what is so important about the bread in the car and the peanut butter. That would just be something I wouldn't forget that testimony, because it just kind of stands out. But I'd be waiting for what is the significance of it, other than saying an inconsistency, saying what the bread is for. But that was a fun fact.
Yeah. I think it's just to show that they didn't just end somebody's life. They were all joking around. It was all cool and fun. They were making peanut butter sandwiches. They didn't just, have this big conspiracy that just happened.
And again, lastly, Levenson was in the house. So that's
correct. Correct. Yeah, you said that. Okay. Next is Katie Mclaughlin. I'm ready. I really want to hear what you heard about, or what you felt about her, because she was a big topic of conversation the first trial, and we'll talk about why after we get your take. Today's episode was sponsored by OneSkin. OneSkin was founded in 2016 by an all-woman team of scientists with PhDs in skin regeneration, stem cell biology, immunology, and bioinformatics. After testing the efficiency of more than 900 so-called anti-aging peptides, they developed the OS1 peptide, the first ingredient to reverse skin's biological age by reducing the accumulation of senescent cells, a key driver of skin aging. And it has all the scientific backing and research backing for anti-aging, but I love the way it feels on your skin. It's hydrating. It makes you feel great, especially, after the sun, or if my skin is feeling dry. I love to use it. I love the way it smells. I love the way it feels. That's why I use OneSkin. OneSkin is the world's first skin longevity company. By focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. For a limited time, you can try OneSkin's 15% off using code LYK at oneskin.co. That's 15% off oneskin.co, C-O, not C-O-M, with LYK. And after you purchase, they'll ask where you heard about them. So please support our show and tell them we sent you. Give your skin the scientifically proven gentle care it deserves with OneSkin.
Okay. All right. Well, obviously, the important things are, I hit him, I hit him, I hit him. Again, we have a 3 times I hit him, but I think, again, this is me listening to it. It seems kind of incredulous to me that, does she always say things 3 times, or and it doesn't seem like this is the same 3 times. I think that they pointed out and they showed that video that this was apparently a different 3 times that I hit him, I
It
hit
would
him, I
have
hit
to
him.
be because it couldn't be
Yeah,
the same. So it would have to
right.
be an additional time, which is still wild that all these other people didn't hear it.
And of course, no report. She's a paramedic. She's trying to find out. Think about it. You're a paramedic. If you're not even trained, just think about it. You're trying to find out what caused these injuries. Was it a blunt instrument? Does he have a crushed skull? I hit him. You don't ask another question after the statement, I hit him. Did you hit him with a car? Did you hit him? Did you run over him with a tire? Did you hit him with a tire iron, a baseball bat? No other question. And again, not in any report. And then the thing that struck me, and I think is kind of a theme that's going to be throughout this trial, is Officer Sharif. I guess was there, and Officer Sharif.
I think it's
McCabe told
Sheriff,
her,
but I'm not sure.
Sheriff,
I
Sharif,
think
Sheriff.
it's something like that, but I 100% agree with you. We've heard his name way too many times for them not to call him.
Right. He is so key to the defense argument, I believe.
He's not good for the Commonwealth.
What?
He's not good for the Commonwealth.
No. And because, again, no report, nothing written. Here he is at a death. The argument is this was not a crime scene. A lot of people are saying that, but he's at a death. He hears someone confess to hitting the person who is dead. And what does he do? No report, no entry. And later on, apparently, we find out he doesn't tell Lieutenant Gallagher about it as well. And
I don't want to spoil it for you, okay? And I don't want to jump ahead, but I believe Officer Serif did not hear Karen Reed say that. Oh. And I believe Officer Serif did not see a big old shattered taillight. I think that's the same. I don't know. We're going to have to wait and see if that's what he testifies to, if he does testify. But I think he is like very good for the defense. We'll see, though. We'll see. Because some testimony has changed from trial 1 to 2. So we'll see. And I could be misremembering.
Again, remember, I'm looking at this as a juror who's just hearing this, and I'm hearing that a police officer heard her confess to hitting the body that's laying in the snow, dead, and I don't put it in a report, and I don't arrest anybody.
So you're looking at him as like a negligent cop. That's how you're hearing Sarah. That's really fun. So yeah, and I mean that could be the case, right, too, because there's been a common theme throughout this. That's really interesting, and that's why this is kind of a fun discussion, talking about the facts where you're just getting them from right here with some of these smaller witnesses. That's really interesting to me. Yeah. And this is a good example of like the jury is not seeing it like all of us folks listening. Just so you know, the jury is not seeing it the same way we are. They're not picking up on certain nuance.
And as a juror, there's no doubt in my mind I'm going to hear from this officer.
Right.
Here's the officer. They're on the scene. These are paramedics that heard I hit. These are other people I hit. But this is a police officer, somebody who hears a confession, alleged confession. I hit him. Boy, am I going to hear from that guy.
And all the witnesses say, I didn't push. That's the police job. That's not my job as a paramedic. That's the cop's job, right? They all said that. Right. It's a good point. Yeah.
Yeah. So I'm telling you, I am, as right here sitting here, I assume it is a fact that that police officer heard her say, I hit him.
Which is something that the defense has to clear up, right?
Right.
If it's not a fact and they want to argue it, the defense has to clear that up.
Well, if the prosecution doesn't call him, I don't know how the defense can't call him. I mean, they're going to have to.
Agree.
Otherwise, they're going to leave the jury with the impression that she absolutely told a police officer, I hit him. Mm-hmm. And then, of course, again, one of the common themes we talk about is the Albert and the family connections that everybody has. And this paramedic is also has some kind of connections to the
Okay, so you did pick that up. Okay.
yes, the Alberts.
That was what I was waiting for, because the first trial, they went in on that. It was so clear. It was a sketchy-ish kind of part. Like these pictures, she said she didn't really know her. Jackson got all into it. They found all this stuff. It was a big part of the first trial. They talked about it this trial. I didn't know how it would come across from somebody that didn't see the first trial. So you did pick up on that. There's some connection. And I do think the defense has done a much better job of subtly, just absolute fact, these people are connected with everybody. I think they've done a really good job this trial. Even if it didn't come out quite as bombastic this time around, you still picked up on it.
Yes. Oh, yeah. The family connections are all tight, which also, though, made some of the witnesses who had no connection a little more credible.
Yeah.
So the defense is really honing in on all these people. It's an incestuous situation, but then they've got these witnesses that are going to have some pretty damning information that have no connection to these people, to the Alberts and the house or anything like that, and it makes them credible.
Yeah. No, I agree.
So that's
right.
the
next is a big one.
Yes.
Officer Gallagher. So I want to get into Gallagher, but one of the things I thought about is how much fun would it be to cross Officer Gallagher? Like, I mean, this guy, it's crazy. And again, listening to him, I know we talked before and you thought, I think Michael Easter is his name, the guy they were going to call as the expert on investigations. I mean, he would have eaten this guy alive with what he thinks was a really great investigation, and all the tools he used were really great. So tell us what you thought of Officer Gallagher.
Well, I'd be scared to live in that town. I mean, all right. He was a sergeant, I think, when this happened, though, wasn't he? Wasn't he a sergeant?
He was high up. I don't remember, but he's retired now. That's all I know.
Yeah, but I think he was a sergeant.
He was like the top guy there. He was the guy in command.
Yeah, he was. So here he is. And of course, we all know he's the leaf blower guy. He's the red Solo Cup guy. He's the stop and shop bag guy. I mean, he's that
and he
guy.
wanted to film it. It was so good. He's like, hey, bud, get your phone out. Film me doing this.
Right. But the key about the filming, I think, is he wanted to memorialize the snowblower, film it, but not write a report. And so I thought, why do you memorialize that part and not have it in your head to memorialize the rest that you do? And I think that what your viewers also need to realize is anytime you have a command officer on a scene, that command officer pretty much tells everybody, do not put my name in the report. Because they don't want to testify, they don't want to waste their time coming to court. I mean, it's a standard practice in every agency that I know of, is that command officers do not want to have their names in reports. And then it'll come up.
People like us will go and just say, every single name we see in this report, we need to ask them questions. We need to take their deposition. We need to call them at trial. But he was not just the commanding officer there.
And that's
he
the
got
difference.
His hands dirty. Yeah. All right. So keep going.
Yeah. And that's the difference. Frankly, he shouldn't have done this. As the command officer, he should not have been the one doing this. Yeah. He should have known better than to gather evidence himself, than to use the leaf blower, the red Solo cups, gather the broken cocktail glass, all of that stuff. He should have known better. And then to sit there and say that you used the red Solo cup because they held liquid terrifically.
They're great at holding
liquid. What kind of a stupid sign, what kind of a stupid statement was that to use a red Solo cup?
How condescending to a jury. Like, dude, are you seriously trying to what you do is, it was an emergency. It was frantic. We grabbed whatever we could. We did the best we could. Absolutely not not best practices, not what we would want to do if it was a perfect scenario, but we acted quickly. We got the evidence and it wasn't contaminated. They were able to get the fact that it was John O'Keefe's blood. That's how you explain it. You apologize for using a red Solo cup. You don't pat yourself on the back for it.
Right. Well, like anything else, you own the negatives in your case. Correct. And if you own the negatives, they don't become as big an issue. You just make them a big issue by trying to excuse it, which Gallagher does all the way through his testimony.
He celebrates it.
Yeah. And then he talks about his suspicion training, or I never heard of
Gosh,
that,
that's
but
so bad.
that was a good one.
But that's what I was talking about. This trial, Brennan has done a better job if he's trying to like trick a jury into thinking they went in, they searched 34 Fairview and they interviewed everybody in 34 Fairview. They absolutely did not. If anybody knows what cops do when they search and interview people, they did not do that at 34 Fairview.
I personally think Brennan did not. Here's where I can criticize him. He
Okay.
did not do a good job preparing Gallagher for testimony. He
Either
did
that
not.
or he's intentionally telling his people to, like Jen McCabe, Yuri Buchanan, Gallagher, they just don't remember certain things, and certain things, I apologize, I can't remember. It seems a little fishy to me.
Yeah, but in Gallagher, it's not I can't remember. Gallagher sits there and is proud of the fact that he used a snowblower and a red solo cut. You're right. What he should have told Gallagher to say is, look, this was a crisis situation. I didn't have any options, and I had to go with the best option possible in order to preserve the evidence so we'd have it here for trial. Otherwise, we wouldn't have it. So, the suspicion training, I didn't think Brian Albert was acting suspicious. My training told me that was just absurd.
Well, he's just the cop that knows. He doesn't have to do certain parts of the investigation because he knows what something's going to show. He knows what people are going to say. He is. I mean, Buchanan is giving him a rival here, but he was my least favorite witness of the whole trial. I think Gallagher was the one that frustrated me the most. That wanted me to be like, if I was a judge, I'd want to be like, I want to throw this case out because this was so bad. That this guy thinks it's okay, and you put him up there and talk about how great of a job he did. This is not how it's supposed to look in the criminal justice system. Like, that guy frustrated me so much.
And not just that, but if you're also a judge and you're trying to rule on evidentiary issues, and there's no evidence log, there's no chain of custody, nothing on this evidence. So again, this is a supervisor. This is the guy who's training other people. So,
and they act like it's perfectly fine. They're like, no big deal. That's great. Yeah, that's just how we do it. And you know what? We don't need logs because we have cops that can come and testify to us and say, trust me, I handed it to this guy. I trust the criminologist. We handled this investigation with honor and integrity. It's like, we can't just take your word for it. I'm sorry. Just like you can't take the word for a witness. You have to corroborate, get evidence, trust, but verify. We would like to do the same thing for you. And how do we verify it? With an evidence log, with a report, with documentation that you don't have.
Many times we've both had this happen. A prosecutor will get up and say, Judge, we don't have that document, or the witness doesn't have it. And we tell the judge, we believe the prosecutor is telling the truth. We know he wouldn't lie, but we would still like to take the witness's deposition in order to verify that they don't have the document. You just can't accept it. But that's the end of the day. That was the end of that day.
And then Gallagher continued, I think, the next day. Yes. So if there's anything else you want to talk about with Gallagher. But one of the questions somebody had for me is, has a cop ever come out up to you I think they even said a witness. And I said, the ones that get really contentious for me have been like law enforcement, cross-examinations and testimony, but it's never happened to me where they would come after me in the hallway. And you let me know and said that it has happened to you. So why don't you tell us a story you want to talk about, or occasions where that may have happened to you?
Well, I've actually been pulled over by deputies who I have really reamed in trial. And they've pulled me over, and I've had both experiences. I've had the deputy come up and say, you remember me? And I said, frankly, a lot of times I say no. And he goes, I was the witness in that guy's DUI trial, and you got he was guilty of sin, you got him off. And then he's sitting there berating me, and then I didn't say, and then he goes, and then he didn't give me a ticket, so I wasn't worried. And so then he just turned around and went back to his vehicle. And that's happened to me more than once. I've also happened to have them pull me over and say, you did a great job. They actually come up to the car and they say, I wanted just to tell you did a great job. Mm-hmm. But my scariest story was many years ago when the United States invaded Panama to get Noriega. I had a very key witness for the United States, Noriega's best friend. And so I flew down right after the invasion. And right after the invasion, you had to have permission to enter Panama. So I had to have a special document. Only one plane a day landed at the airport. And everybody on there was an official. You got out. They went through your stuff with dogs. They put everybody on a bus. They drove you to the only one hotel was open in the entire city of Panama City in order to house government officials, basically diplomats, Department of Justice, FBI agents. They were all in the same hotel with the one restaurant. And well, there happened to be a second restaurant open, which is another story, which was a Greek restaurant across the street, amazingly enough. But anyway, one restaurant in the hotel. So I went there with some FBI agents who were accompanying me. We were down there eating. FBI agent from another jurisdiction who knows who my client is comes up to me and tells me, "How can you defend such a scumbag?" And I don't know if I can say that. And I stood up. I stood up and I said, I said, "Look, you guys," and I started just ripping into the guy about the way dirty law enforcement, how dirty cops are, and that you guys should have integrity, and you don't have any. And the other FBI agents had to actually separate us because this guy was so out of control. And again, I'm in a foreign country. I'm a guest of the United States government in that country, and the FBI agents had total control of the company as well as the country as well as the army. And that was probably, I didn't, after I sat down, I said, "Boy, what an idiot." I said, "I'm sitting there."
Bad. Definitely bad.
And I'm sure he's got his guns and stuff. And I'm sitting there, but that was the worst experience because I was in, again, foreign country, and the United States government controlled that country for months.
Yeah. Yeah. So it can happen. It can happen.
Yeah. Oh yeah.
Okay. Anything else with Gallagher that you want to talk about?
Well, no search warrant. I thought that was we
didn't even try for a search warrant because, as you know, Dad, any cop that gets denied a search warrant is now on a Brady list, and he's going to lose all integrity. It's like, that's not at all how it happens.
Yeah.
He's like, yeah, sure, if you lie and you commit fraud, sure, but just because a judge doesn't sign your search warrant doesn't mean you lose all credibility to testify. But that's what he was trying to say.
And he had plenty of probable cause.
We disagree on that, but regardless. He definitely had enough to try and get a search warrant.
Well, no coat, no shoe. Now, I mean, there were just all sorts of stuff, and he could have had the witnesses, but anyway, he didn't even try for a search warrant.
If that was my client, if the Alberts were my client, I would argue profusely there's not enough probable cause to search their house. But if I'm looking at it realistically and what cops actually get search warrant signs with probable cause, they probably had enough, right? I mean, it doesn't take much.
And then he did make a statement about tripping and falling, which I thought was interesting. He did say something about that's a possibility.
Yeah, yep.
So, that was him. But yeah, you're right. He was terrible. And if he was still in the department, he shouldn't be.
Yeah, I agree. All right. Yeah. The next witness was the meteorologist.
Meteorologist. Clean, all-American testimony. I didn't see any issues with him. And both sides got what they wanted out of him, and I think both sides are going to use him in closing argument. But that was an easy one.
Yeah, not really a big deal. There were some snarky responses in cross, but not a huge problem for either side. Next one I think was Lieutenant Ray. Is that right?
No, Garino.
Oh,
Garino made the text messages.
Messages. Text messages, and then another video clip. Yeah.
Right. And then we've got the interesting thing about, again, that's the reason why I brought up the charges in the beginning, because I don't, these text messages I don't think help the state, except maybe for that middle one, the DUI manslaughter. Because I think if I was a jury, she convinces me that she didn't know that she hit him.
You mean the voicemails? You said text message, but you mean the voice. I 100% like that.
Yeah,
would, if I was a prosecutor and I heard these voicemails, that charge would be off the table. There's no way. I don't care if you can prove that John O'Keefe got hit by a car. I'm still not charging that top charge once I hear these voice messages.
Right. So I was convinced that she didn't know, and then the timing. Obviously, the timing is after. The Commonwealth says the accident happened. The stuff she said on there, and then again, was she drunk? No doubt in my mind. After hearing those messages, so those didn't help. I don't think they didn't help at all, except maybe they wanted to prove she was drunk, but they didn't help their timing, and they didn't help the other charges.
she hated him. She was so mad at him. She could have ended his life. I think that's what they're trying to prove. I'm not getting that at all.
Yeah, but I just don't know if they helped them that much other than that. Um,
The
and then
video
they played
clip.
the video clip. Um, Again, I don't know if that helped or made any difference at all when she said, I didn't know if he was mortally wounded.
Uh-huh.
I think that helped the defense, and
Okay.
so I don't think it helped the Commonwealth, but they put it on anyway.
How does it help the defense?
Well, because again, I hit him. It was did I hit him?
Could I
I
have
hit
hit?
him.
Could I
Yeah,
have hit?
yeah. So those are that's the key here. Is the statement "I hit him"? Is that a confession? That's going to be. I think they're going to sit back there and they're going to talk about that for hours in the jury room, whether that was a confession or not.
Uh,
And if it's not a confession, then I don't think they've got a good case. I think the
yeah.
case is history.
Yeah. Oh yeah. There's a lot still to come that could prove
Right.
it. But all right, then we get to Lieutenant Ray.
Uh,
He was the one I think he just like took a picture of the tail light.
I mean, I think it shows some damage, but it certainly doesn't show as much damage as has been testified to.
So that's what you think. You think there is a discrepancy in the testimony and the pictures that you can see of all the missing tail light pieces.
Yes. I
Okay.
don't see how there could be. How many was it? 43 pieces or 40?
Yeah.
How many pieces they testified?
Yeah. 40 plus.
Yeah. I don't see that missing from that tail light.
Okay. Okay.
I
I'm
know,
really
I know
interested.
what you thought, but
It's just impossible for me. I don't feel like that would be a key in the case to me. It just wouldn't. Like all the snow, all the reflections, I just couldn't really tell. I think the bigger problem is how do you not find it during this search, that search, the other search? How are you finding it days and weeks later, driving? But like the snow melting is just not enough for me for this evidence to reveal itself. But the actual picture of the taillight is not as big of a deal to me as how do you not find it in these searches? That is what seems crazy to me. The picture, I don't feel definitively I can tell that the picture is the same or different. And again, that hurts the Commonwealth. They're the ones that has to prove it to me. And for people that think that's unfair, that's how criminal cases work. If I don't really know and nothing's being proven to me, that's a win for the defense. Okay, the next one is Kevin O'Hara, the CERT team, which is they bring the guys there to search 8 people shoulder to shoulder. They walk it. They make sure they find every single thing. What did you think about him?
O'Hara was one of the guys I talked about that had no connection to the Alberts.
Right.
And so that gave him credibility. I think O'Hara was credible. He can't help the problems in the case, and he can't help when they found other stuff. But he was credible in what he said.
Mm-hmm.
The unsecured scene obviously is a big deal, and they found the location of where they found the 7 pieces of tail light. Those are going to be big deals, but I don't doubt what's the good way to say it? I don't doubt he's telling the truth.
Yeah,
And
I
that's what I'm
agree.
saying.
So one of the things that Hank Brennan did way better this time, like you didn't even pick up on it with O'Hara. Last time, it seemed like there were multiple non-officer random people that O'Hara had no clue who they were that were just there on scene that day. I remember that stuck in my head from the first trial. Well, this trial, he was like, they were officers, just people I didn't know personally. They were in civilian clothing with Tully, I think. And it was either Tully or Gallagher. I can't remember. They were there, but I didn't know who they were, but they were definitely officers. That was very different and more specific testimony this time that Brennan got out than last time. And he also did a better job of saying, we only searched the street. 99% of what we searched is the street, not the yard, which is a distinction on why they may have found pieces that they didn't find with the CERT team. That was a much better job by Hank Brennan than trial number 1. Because you didn't even pick up on that there might have been random people that were not law enforcement there.
No,
right.
Like I said, I'm only looking at what O'Hara said, and like I said, I thought he came across as credible and believable.
Yeah, and it was more of a more specific questioning than it was a lie or a change in testimony when compared with his first testimony.
Right.
Okay. Next was Connor Keefe. Is that who you have?
Yes.
Okay. What do we got here?
Well, he is a real key. Now we're really starting to talk about Proctor. And he was a real key in highlighting who Proctor is, who Proctor was. Um, I mean, this guy, he's almost like a fresh-faced kid, up there because he's never been a lead investigator himself
But he confirmed
on
that
homicide.
Proctor was the lead investigator
Right,
and this was his case, which is very important when we compare it with Yuri Buchanan's testimony coming later. He
right.
already confirmed it. So it doesn't help you to quibble and lie about this in the future when you already have a cop saying this is Proctor's case, he's the lead investigator.
Yeah, and so he didn't dance. I mean, he came out and said, "I didn't know." I think, hey, I mean, let's face it, he's a prosecution witness. You can't, he's going to be a prosecution witness. I mean, he's not your witness, but he did
No,
answer the questions. He did answer the questions. He did
yep.
say he was the lead investigator, and I think he said it 3 different ways, 4 different times. I think
Yeah. Yeah.
because of the questioning. Um, the other thing is, again, it's just my quibbling. He went to the autopsy. Proctor didn't go to the autopsy. That's an unusual thing, generally speaking. Generally, the lead investigator goes to the autopsy. So I thought that was kind of interesting that Proctor
Yeah.
did not even go to the autopsy.
I mean, I don't think that happens in every scenario. So it's not like that alone is some like major
Right.
red flag. But
I know.
it is interesting when you know about the conversations coming later, which are rookie couldn't even get a homicide designation or something like that. That's coming later. And this is who they were talking about.
Okay. And then the other is how he didn't remember that he interviewed or was present at the interview of Levenson.
That was
Didn't
wild.
he review his reports? Didn't he prepare for his testimony? I mean, isn't Brennan preparing these guys? How can he not know that Levinson was not somebody that he was present at the interview for? I don't understand that, but again, those are the keys I remember from his testimony.
Yeah. Yeah. I think that was the case. This was one of the witnesses where I was like, Hank Brennan, there are a lot of witnesses, especially the first trial, that were better for the defense than the Commonwealth. This was one that was better for the defense than the Commonwealth from the prosecution side. Okay, then we're going to get into the expert Hyde. Before we do, did you listen or hear any of the argument about the motion that they wanted to impeach her credibility with what another court found that she basically shouldn't be able to testify, or it's not as strong of testimony as she's trying to make it seem, and didn't allow her to make certain comments in a prior trial in Maryland?
Yes, I did.
What did you think
Um,
about the fact that Judge Cannoni did not allow them to use that to impeach her credibility in this case?
I think that there was a way to use it to impeach her testimony. I don't think it's proper to say a judge's order, but I do think it's proper to say, isn't it true that in a prior trial, your testimony was questioned because you weren't able? I think it was the. I got a frog in my throat today. Excuse me one second. In a prior trial, you weren't able to talk about the Apple data because it's secret. Nobody knows about the Apple data or how Apple does their stuff. Um, and I think you're
Here's
able to say, isn't it true that because you don't have the Apple stuff, your testimony isn't as strong as it could be? Or hasn't your testimony been questioned because you don't have the Apple data?
or
There was a way of doing it.
or at the very least, your testimony has been limited by another court. That's it. Like that alone sometimes is enough to hit the credibility of an expert witness. And usually it's pretty broad what you're allowed to do to an expert who has all this education experience and their credibility is such a big deal. If it has been limited in another case, this jury should know about that if it's relevant, which of course it is relevant to her testimony in this case. It's not like they're
Right.
saying, you testified about a dog in another case and you're testifying about a computer here. Like those are two completely different expertise. But all right, what did you gather from her testimony?
I basically I don't know what the defense is going to do to change the jury's opinion that the Google search was at 6:24 a.m. I know they were able to question about there were certain or cell phone events that weren't reflected on her chart when she did the investigation. Wasn't there a FaceTime shut off or something, or face shut off, or I know they did all that, but the point is there's only one. The one point is 6:24 a.m. for the Google search. Second expert who said that. I think right now the jury absolutely believes it happened at 6:24 a.m. But she did say that steps can be manipulated. being in the car. Those kind of things can change the steps that a phone records. So I think that she is consistent with the first expert that some of this data can be manipulated. And that's something that I'm sure the jury didn't forget when she said it can be manipulated. But as far as the 624, right now that's cast in stone unless they've got some great expert on the defense that's going to be able to prove otherwise.
Yes, you think absolutely they think that the Google search was at 627. That's interesting. To me,
Yes.
that seems like such a side issue if I'm a juror that like I'm not even sure yet. And of course, the defense is going to have experts. We'll see how their experts are going to compare to the Commonwealth. I think it is going to be a battle of the experts, but you think, based on what they've heard so far, that they're pretty locked into that.
Yes.
Okay, interesting.
Yes.
Interesting. Okay, what about? I think next is that Yuri Buchanan. Is that who's next?
Well, they played this important clip.
Okay, go for it.
Where she said, "I'm not going down, Jen. You are, or Jen, you're going down. I'm not going down." That clip.
Like it's you or me, basically.
Right. Bad move by the Commonwealth. And again, my opinion. What did that prove for the Commonwealth? Did it bring in Jen? Are they going to have to prove Jen didn't do it? Did it raise an issue with Jen? Did it bring Jen into a highlighted position even more than she was, as being the only other possible defendant? Or either it's Jen or Karen Reed. I mean, why did they play the tape? I don't think they proved anything, and I think they created an issue that they didn't need to create.
I think if I was going to guess why they did it, it was like Karen Reed is trying to pin this on Jen McCabe, even though she has nothing. But I agree with you. I think they have now created even more thought. Did Jen McCabe do something? Is she involved? Why do we keep hearing her name like this? I thought that was a swing and a miss for the Commonwealth personally.
Yeah.
All right, next is Yuri Buchanan.
Brennan's trying too hard to use these clips. He knows how important they are and how damaging they can be. And I think that he's just trying too hard rather than just picking out the good ones. I think that's what happened.
I think that some of them he's done a really good job with. Mm-hmm. Other ones he hasn't. And that was one that I think was just a complete swing and a miss.
Yeah. Okay.
All right. Buchanan is next.
Okay. How do you pronounce his name? Is it Buchanan?
Buchanan. You can just call him Yuri, B, whatever.
Okay. All right. The number one thing to me is the Proctor testimony. He was again, there was no need for it. Absolutely no need for it. It's already come out. He looks like an idiot. He looks like he's trying to lie. He looks like he's trying to mislead the jury. So trying to mislead the jury is a bad look for any witness. And the jury absolutely believes this guy was trying to create testimony and trying to lie to them to snooker them. And I think that's what the jury believed. He's lead investigator. What's that? We're all on a team.
Team game.
Yeah. Proctor was just a random assignment. I was with Proctor, this one, and I understand why he did it. And it would have been more effective if this guy hadn't denied Proctor was the lead investigator. I understand why he said were you with Proctor all day? Was Proctor attached to your hip? Those are really important questions. But the fact that this guy was dancing around Proctor as the lead investigator ruined his credibility with the jury. And I believe the jury doesn't believe what this guy says. That was the key for me is the Proctor. And then obviously his credibility. And this is what Brennan should have done. He should have owned it. He should have owned Proctor just like he did own this guy. He did come out and say, were you, punished? Yeah. Did you have your 5 days vacation time, failure to supervise, and not accurate review? Now, you know what not accurate review is? He lied on his report. He lied on his review of Proctor. So, I mean, that's a lie. That's what that is. And everybody knows everybody works for somebody who gets a review. And if that review is not accurate, it's because that person lied about you. And that's what this guy did, is lied about Proctor on that review. So tell me, is that not bias to lie on Proctor's review? Is he not biased for Proctor? And we
Well,
see that
he's definitely trying to cover for Proctor. That's for sure.
yeah. But I understand the questions, but they just killed it. Let's see what else. I don't know. Proctor was the thing that I highlighted the most. It just struck me all through his testimony.
Well, he's the key guy. He's the key guy. And in Cross, him being the key, he's the lead investigator, right? As far as the Commonwealth is concerned, he's the lead investigator. This was his case. That's how they're having him testify. How does he not know all the things he says I don't know about to Alan Jackson? I don't know who did that. I don't know who I handed that to. I don't know who filled out this evidence bag. I don't know who gathered that evidence. I don't know who did this. And then he said, if you show me a report that was offered by me or Proctor, I'll take it as gospel and I'll testify to it. I was like, come again, sir? That was wild.
Right. And then he also goes, then this was at least for me, maybe as a lawyer, I read too much into it. The fact that Jackson goes to the judge and the judge admonishes him and tells him to answer the question. So I thought that was important. Even to the judge, this guy was not answering Jackson's questions.
So when a witness is incredibly evasive, trying to like mess with you, saying, "Oh, I hate to do this for you," and Jackson said, "I doubt that," or "I seriously doubt that." What's going on in your head when you're crossing a law enforcement witness like that, and they just continue to be evasive? What are you thinking?
Keep going.
You cannot quit. You have to be patient.
Yeah. And the more he does that, the worse he's going to look. There's a lot of witnesses you want to get on and off the stand quick. But there are some witnesses, the more they talk, the better off you are. And this was one. The more this guy talked, the bigger idiot he sounded like.
I think there's going to be a lot more after we're recording this in the middle of the day on Friday. So we haven't seen the end of Cross. We haven't really gotten down the Proctor line yet with Jackson. So I'm sure a lot of that is coming this afternoon, and we'll have to talk about it on next week's podcast. But I mean, it's not going well for Yuri Buchanan. It just isn't. I don't see a jury finding him credible personally. Now, they probably don't hate his absolute guts like they would for Proctor, but I still don't think they find him credible.
Well, Proctor doesn't taint the investigation.
Honor and integrity.
Honor and integrity. Proctor has honor and integrity. The investigation has professionalism and integrity. All that, that was ridiculous. And then, and again, I thought this was really important, and I'm sure that it's going to be hammered home later. There were 3 searches at Fairview, February 3rd, 4th, and 10th. When was the report written? November 4th. How do you write a report on November 4th for searches you did in February? Yeah, how do you do that? 18 months. Is it 18 months? No, 8 months. I got 8 months later. How do you do that? So that I thought that was really important, and they did hammer that home. So this guy basically has no credibility, and they're trying to use him to give Proctor credibility, and that ain't going to work. And again, I think they've made a mistake from the opening statement in just owning Proctor as having problems with being his integrity. Just own it and just live with it.
And like you said earlier about, it just seems like Hank Brennan is not preparing some of these witnesses. You definitely get that feeling with Yuri Buchanan, that he just was not even prepared, or this is purposeful, one or the other.
Yeah, because he could sit down. It is legal for him to sit down before this guy testified and tell him, what was the guy's name? Keefe? Was it Keefe? Keefe. Tell him, hey, look, I want to let you know, Keefe testified that Proctor was the lead investigator. So it's out. The jury has heard it, and I want you to know that.
So they tried to make it seem like all that was nefarious, and the rule of sequestration, witnesses can't be in there, but you are allowed to prep your witnesses. You are allowed to discuss what's going on in the trial and not necessarily violate the rule of sequestration. You are allowed
to do that. Yeah.
Certain parts. You can't say this person said X, Y, and Z, but they can still meet. You can still talk about stuff. They're not allowed to watch the full testimony. Right. So you have to be careful, though, because you cross that line and it can be problematic.
Right. So
Um,
telling him, look,
it's already
Proctor
out
was
there.
the lead investigator. That's it.
You shouldn't have to tell him because that's already the truth. But
Right.
um, and you don't have to say Keefe testified to it. You can just say
Right.
Proctor's a lead investigator. So
Yeah.
that it is what it
Yeah.
is. That's what we're going with. Um,
Right.
all right. So a couple other things. Two more things I want to talk about. Number one, there is an order limiting media coverage for John O'Keefe's niece and nephew, which means they are going to testify again in this trial, just like they did the first. We didn't get to see it the first trial. We are not going to see it the second trial. What are your thoughts about the Commonwealth calling them?
It's got to be a sympathy. I mean, I can't see any other
Sympathy, and
reason.
reports were that last trial they talked about issues in John O'Keefe and Karen Reed's relationship.
Let me ask you a question. So, I'm sure you can tell me, was Karen Reed with them at midnight? Was she? Remember,
At
she's
12:36, you mean?
yes.
When
Was
she
she
got
with?
home, I
Yeah.
believe the kids were, yes, at home, and she stayed at John O'Keefe's house.
That's
Even though
that's
she
the way
said,
I.
"I'm leaving," yeah, I'm leaving. She did stay there. She was just trying to get him to come home, is what it seems like.
Right. That's the way I interpreted the phone calls. Is that she was there and she was watching the kids. So
Watching, I mean,
I'm
she was probably pretty drunk, but yeah.
right, and I'm wondering if the kids knew anything about that. I'm wondering if the kids were awakened or were awake, saw her, saw how she was acting. I'm wondering, what they testified to. But even that would be a sympathy testimony. That I feel sorry for
Yeah.
these kids that had to endure that.
Okay. And the last thing I want to get to, and potentially the most important, twofold. Okay. We'll start with the quicker and easier one. The people inside 34 Fairview that testified last trial. Doesn't seem like the Commonwealth's going to call all of them. Do you see any reason, if you don't really know what they testified to in the first trial, you may not even be able to give an answer, but do you see any reason for the defense to call them to try and make it look like there's this conspiracy, to try and make it look like they're lying, and to get out the fact that all of them walked right by that small yard and did not see John O'Keefe's 6'1", 215-pound body in the snow?
Depending on how many of them testify at the trial that they did walk by, I don't see any need to call them all. I don't see any need to call more than just a couple.
Yeah.
Um, you know, uh, and I don't think you're going to prove your conspiracy theory by calling those people and questioning them. They're not going to give you anything that's going to prove your conspiracy theory. I would stay away from them, just like if I was the prosecutor, I'd probably stay away from them too, unless I had to.
Right.
But I'd stay away from them. There's no reason to call them.
So a follow-up question everybody has is, knowing the defense might call some of those prosecution witnesses, is it ethical for a prosecutor to still prepare those witnesses in case they call them, in case the defense calls them, and tell them, like, if the defense calls you, they may ask you these kinds of questions. We might same kind of prep you would do, even if you're not the one calling them, but they're a friendly witness to you.
Yes, you can do that. You can
Yeah, we
prepare
do
a
it all the
witness. You can prepare them for cross examination. You
time.
can
Absolutely.
prepare them. Yeah, you can prepare them. The only thing you can't do is say, "Let me tell you what Joe Smith said when he was on the stand last
Sure.
week." You can't
Right.
do that, but you can sure prepare them, and it's totally ethical to do that. And Brennan should. He seemed like a very prepared guy. His opening seemed very prepared, but some of these witnesses were not prepared,
All right.
especially
And then
this week.
for the big question, if first off, how surprised would you be at the beginning of the trial when you hear about this case and you know who Michael Proctor is? How shocked would you be as a defense lawyer / juror, if you were a juror, that the Commonwealth does not call lead investigator, former trooper Michael Proctor? And if they don't call them, answer that question first. Then we'll get to, if they don't call him, would you call him if you were the defense?
I would be surprised as a juror if Proctor did not get called by the Commonwealth. Absolutely. And I don't think we've heard the last about Proctor.
Right.
I think that, we got a couple more weeks of testimony coming here from the Commonwealth. And I guarantee you Proctor's name is going to be mentioned as much as possible during those couple of weeks. That's what they're going to do. So it'd be a big mistake.
But what
And
about as a
nothing.
defense lawyer? Would you be
All right, let me,
surprised that they actually didn't call him after they called him the first trial? He's so intricately intertwined in this. Would you be surprised, or how would you feel if you were the defense lawyer? Like, how often has that happened to you where they don't call the lead agent or lead investigator in a case?
It has happened to me sometimes, but only because the lead investigator did not do anything that was particularly significant.
Which is
And that
which is
was
not the case here.
right, which is not the case here. So
Have you ever
it would
had
be
somebody this intimately intertwined and involved,
no,
collecting evidence, interviewing every single witness? This guy basically interviewed everybody, and they're just not going to call
no. That never happens. It
him.
doesn't
So it's
happen.
shocking.
Yeah, and tell you another thing too. If the Commonwealth was going to call Proctor, I'd call him now. I would
Yeah,
not wait till the end of the case. I'd
yeah, I
call him
agree.
now, put him in the middle of the hubbub, and then put on this great expert testimony you're going to have, theoretically, so
Mhm.
that maybe they'll forget about how lousy Proctor was. But I certainly wouldn't wait till the end of the trial to put Proctor on.
Yeah, I agree. I agree. I agree. And so you would be surprised that they wouldn't call him.
Yes, very surprised.
If we were the
Absolutely.
defense, we'd be like, yeah, they have to call. I mean, we know he's bad, but they have to call him. That's what we would think. Okay. And if they don't call him, knowing some of what you know, and obviously you don't know everything they would get into with Proctor, if you were the defense, would you call him?
Yes, I think I would.
And how do you think? Because so they have text messages that are damning, things that he said, people he knows, relationships he has with everybody, timing of when he bagged certain evidence. Was he alone with the car? Could he have smashed the taillight? That type of stuff, right? How limited will the defense be calling him as their own witness versus what they would have been able to ask him on cross, in your opinion?
If the judge does the right thing, she's going to let them lead and ask leading questions because he's definitely a hostile witness. I don't see how the judge can say anything other than the fact that he's a hostile witness. And it'll come out real quick that he's a hostile witness. If she doesn't, I mean, he's gonna start snipping back at him. Uh, there's a chance the prosecutor won't call him, and the reason there's that chance is because he didn't mention him in opening, and that's
Well,
kind of a
we're
go
past
ahead.
that. We're past that, right? So we're focused now on
No,
if you're the defense, what would be different about if you had to call him versus if you're cross-examining him, right? That's the question. So
okay,
do you think you would be limited in any way having to call him as quote unquote your witness? Yes, you can ask leading questions, but is there any other limitation you could think of that might happen from that?
no, and I don't
I
think the
agree.
jury will be shocked when he says stuff like what was that guy's name? I can't pronounce his name.
Can't, can't.
Yeah, they won't be shocked when he testifies. All the evidence led to one conclusion. I mean, he must have said that about 20 times in his testimony. They're not going to be shocked that Proctor is going to say all the evidence led to one
Yeah.
conclusion. So, that's not a negative. So you can put him on and just show again, I think the word I used before was stinky fish. I mean, he put him on to see
Something.
what a
Yeah.
stinky fish this guy is. And so I think that's worth putting on to show how stinky he is.
And some people were saying, well, the judge isn't going to allow self serving hearsay with some of these Proctor text messages, but maybe they'd be able to use them as impeachment. I still think the defense is going to be able to ask the right questions to either turn them into impeachment or they're not used for the truth of the matter asserted. They're not used to prove that Karen Reed leaks poo or that, whatever it may be, that he actually was searching for nudes, but instead Proctor's state of mind, his bias in this case, how he was looking at Karen Reed, how he was talking about her, and why he was ultimately terminated.
If I remember right, and this is all memory, the judge didn't let them put on their expert as to criminal or police investigations.
Correct, correct.
And she said the reason is I think the jury can make their own decision about whether or not this was a lousy investigation. Well, if you take that ruling the way it really she intended it, I believe, then putting Proctor on the stand, they should be allowed to get into his bias, his prejudice, all those all that stuff to show how lousy the police conducted their investigation in this case. Since we can't put an expert on, Judge, then we have to actually show the jury what really happened in this case. And I really think that she's going to let them do it if they put Proctor on. I
Yeah,
think she
I think
will.
she has. I don't
Yeah,
see how you don't let them ask every single question in the book on Michael Proctor. You do not
absolutely.
allow the prosecutors to not call a lead investigator who did everything in this case and allow that to limit what you would allow a defense attorney to ask if they would have called. That's just not how it's supposed to be working. It's not a game. Somebody's life is on the line here. Somebody's life has already been lost. Yes, there's some strategy. Yes, lawyers are going to do certain things, but you can't play games like that, which is almost why I almost feel like there should be some rule or law that you cannot do this if you're the Commonwealth. You cannot not call the guy who did everything in a case like that. It just doesn't seem right, frankly. It doesn't.
I don't want the rules to try my case for me. So
get it, but
I want to
doesn't
make my
seem,
own decisions as who I call as
in
a
the
witness,
interest
whether
of
I'm
justice, this does not seem right to me, period.
a,
So I get why people get pissed off at lawyers and at trials and act like the truth doesn't come out and we finagle it and hide things and want to tell our own story as opposed to what actually happened. This is a key example of that and why people look at lawyers a certain way because of what's happening in this case with Proctor.
Also, think about how Brennan will look if in front of the jury he's jumping up and down objecting to all the questions that the defense is asking. The jury is not going to like that. It's going to be a bad look for him to do that. I think Brennan's just going to sit there and just let them rip into Proctor.
And I think that he's already looking a little bit that way with Buchanan and some of the objections he's making there. So here's another interesting thought I had. Depending on how bad it goes on direct, and I'm putting direct in quotes, when the defense questions Proctor, if I was Brennan, I would seriously consider not even crossing him, not giving them a second bite on redirect, just being like, peace out, Proctor, go catch a ride to whatever you're doing now.
Right.
I would consider not. I mean, you go full in, right? You go all in. You're not calling him. Forget about crossing him. I got no questions for this guy. Buchanan did everything he needed to do. I don't know.
Right. Your listeners should know that's the rule. The rule is if you ask no questions, they cannot come back and ask any more questions. That ends it. And that's the safe way. You're right. That's the absolute way to go.
Yeah. It's been a wild ride already. Any other thoughts on week 3? I think it's week 3, right? I didn't even check myself with that, but on week 3, I believe
12th trial day. Today's the 13th trial day.
It's got to be the third week. Yeah, it's got to be. That's how it's running together for us. But anything else you wanted to mention before we go?
Nope, nothing else.
Hit it all. That was much more structured. I felt better. My brain, that worked better for my brain than the first one. That was kind of a little more all over the place. But yeah, some agreements, some disagreements. But overall, I think we're on the same page with how this trial is going. It's still a lot yet to be proven. Like you said at the very beginning of this episode, they have to connect these dots. The Commonwealth has to connect this case together for the jury to actually prove a crime was committed. Will they be able to do it? Only time will tell. But thanks for joining me, Dad. That's all we got this time. Till next time. We're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.